Good afternoon, everybody, and welcome to the March session of the Devon and Cornwall branch Institute Quarrying Technical Meeting. Just a bit of a request: if you can turn your cameras on, that would be appreciated. I know it's difficult sometimes in terms of network, but it's I'm sure a bit nicer for Bryn to be staring at some faces rather than staring at blank screens. So that'd be appreciated if you can. We've got Bryn Doyle joining us today from an employment lawyer, and giving us a bit of an overview of bullying and harassment in the workplace, as it is becoming a difficult and complicated topic to navigate. So without further ado, I'll hand over to Bryn. One thing just to mention, questions: if you have any questions, please raise your hand, ask them as we go, or post them in the chat. Bryn's more than happy to address them as we go through the presentation. We will still have an opportunity for questions at the end, but feel free to interject and ask away. So without further ado, we'll hand over to you, Bryn.
Thanks, Brian. Thank you, and thanks everyone for having me this afternoon. So yeah, just to reiterate that these sessions work best when kind of people asking questions and saying, "What about this? What about that?" So please do feel free to raise a hand, put something in the chat, or there's a sufficiently low number of us to just ask a question as we go through. So feel free to do so. Just a bit about me. My name's Bryn. I am an employment lawyer and partner at law firm Squire Patton Boggs. I'm based out of our Manchester office, but I cover the whole of the UK. I've been an employment lawyer for nearly 20 years now, predominantly advising businesses. Don't tend to do many individuals, so we advise multinational businesses through to smaller SMEs. The advice that we do is the day-to-day advisory stuff, project work, and also our team do an awful lot of employment tribunals. And a lot of what I'm going to talk to you today about, the experience share, will come from many of those employment tribunal cases that I've done over the years. Louise, if we could have the slides up, if that's all right. I'll be the Chris Whitty and ask you to change the slides as I went. So yep, that's me. So next slide, please. So what we're going to do is we're going to look at bullying and harassment, and you can't really do bullying and harassment without doing an element of discrimination as well. So we're going to look at an element of discrimination, and today's session really is intended to be really to not so that you go away knowing every single thing about bullying, harassment, and discrimination, but just to have a high level, hopefully, overview of what bullying, harassment, particularly in the workplace, looks like, what some of the risks are, and in particular to kind of think about some of the issues that might arise as in day-to-day employment, really. So let's first of all deal with bullying. And ask the question, well, what is bullying in employment law? And the answer is that there is no strict legal definition of bullying. Lawyers, and in particular employment lawyers, like to put things in boxes, and they like to say, right, this is the definition of this and the definition of that. But there isn't anything written down that says this is what bullying is. We tend to get definitions of bullying either from ACAS guidance, for those of you who've come across ACAS in conciliation service, or from case law from cases that we've done. So it's quite an interesting area of the law that there isn't a strict definition of what bullying actually is. And what's also interesting is that there's no standalone claim in the employment tribunal for bullying. So you couldn't bring a claim, you couldn't go to an employment tribunal and say, I've been bullied. That claim doesn't exist. So you might then kind of say, well, why does bullying matter from an employer's perspective? If someone can't bring a claim for bullying, why does that matter? And it matters for a whole host of reasons, and some of them I've put on the slide there. So the first is that whilst there's no standalone claim for bullying in the employment tribunal, there absolutely is a claim for constructive dismissal. And for those of you that don't know what constructive dismissal is, that is where an individual resigns as a consequence of some breach by their employer, and effectively treats themselves as having been dismissed by their employer because of that breach. And bullying can absolutely be a breach. There is what we call the trust and confidence that exists between an employer and an employee. And if an employee has been bullied, then they can absolutely resign, and they can absolutely bring and be successful in claims for constructive dismissal. Now, they have to have resigned because of the bullying, and they have to have resigned in a fairly short order after the bullying has taken place. But it matters, therefore, to deal with bullying in the workplace, because employees who have been bullied can absolutely bring claims for constructive dismissal. They can also absolutely bring claims for acts of discrimination. So somebody can have been bullied for a whole host of reasons, and we see that in the cases that throws up, and often cases of bullying are linked to acts of discrimination as well. So somebody's been treated in a particular way, they've been discriminated against, and therefore, as a consequence of that, they can bring that claim in the tribunal. And we'll look at discrimination on the next couple of slides in a little bit more detail as well. Perhaps the biggest risk, though, for me, is often around environment and employee engagement and so on. And bullying is one of those areas of life where it takes many different forms. It's rarely actually in an employment context is it as blunt and as obvious as somebody picking on someone, as you might find in a school playground. Bullying can take all sorts of different forms, from types of bias to being excluded to words and actions against individuals, and that can create a real toxic environment. And we see that fairly regularly with clients that we're working with, where if there is somebody who has a bullying tendencies, more often than not, the people that work for them may well also exhibit those tendencies as well. So it creates that problem, and it also creates just a general employee engagement. People are obviously much less likely to perform to the best of their ability if they are not happy and being bullied and so on. It matters again because grievances and employees are more and more aware these days of their rights, employment rights, and we're seeing an increasing number of employees raising grievances, raising concerns and complaints about their employer, and being prepared to do that. And an employer then has to invest a significant amount of time and effort in investigating those grievances to try to resolve the situation as best they possibly can. And then the final bullet point there is one that's increasingly important to me, which is about retention and recruitment. So let's twist this around the other way, and if you can create an environment where bullying does not exist, then we're creating an environment that's welcoming and respectful and so on, and that's a great opportunity, in my view, to be able to retain and recruit talent. And we'll talk a little bit more about this in terms of sexual harassment as well in a moment. But we're increasingly seeing businesses, particularly in industries like yours, where traditionally it's been quite difficult to recruit outside of the stereotype of a white male. When you're trying to recruit and retain talent from outside of that group, having a difference, being different, being able to demonstrate that you have a particular policy, or you've got a very open and engaging environment for employees to work within, that's actually a real positive and a real opportunity. And we've worked with a number of businesses at exec level to kind of do that, to promote that, to say, not only are we just ticking boxes about saying, well, we've had some training about discrimination or bullying or harassment, actually we're using this as an opportunity to go out there and say, we're different to everybody else, we're different to these other firms, and we're actively encouraging the recruitment and retention of people who ordinarily we might not necessarily consider our business or our industry to work within, and therefore missing out on some of that talent. So that's why it's important to kind of create an environment that people would want to work within. Okay, next slide, please. So that was bullying. So unlike bullying, discrimination absolutely does have a legal definition. And one of the things that in the legal definition is that we have different types of discrimination. Now, we're going to look at protected characteristics in a moment, and the protected characteristics are those characteristics of an individual, an employee or a worker, who can claim to fit within one of those protected characteristics and therefore have protection from discrimination. Because not everybody is protected from discrimination. A lot of people are protected from discrimination, but you have to fit within one of those protected characteristics, which we'll look at in a moment. And there are two main types of discrimination in employment law. There's direct discrimination and indirect discrimination, and there are whole books, as you might imagine, written on the differences between the two. But in a very high level way, direct discrimination is where I pick on you, I treat you less favorably because of your protected characteristic, but it's about you as the individual. I'm only doing it to you, I'm only picking on you because of your protected characteristic. Direct is where you put in place some kind of policy or provision or something else that means that you as a particular individual within that category, within that protected characteristic, are treated less favorably. So let me give you a couple of examples. So a direct discrimination claim is somebody is disabled and you don't employ that person because of their disability. It's specifically about that individual. It's specifically about their disability that you don't employ them. That's a direct discrimination claim. An indirect discrimination claim is where we've got a policy or a practice or a provision that's in place. So we have a policy within our business that we don't employ people under the age of 21 because we've got a large fleet of cars and we can't afford the insurance because the insurance premiums for anybody driving under the age of 21 are it's too expensive. Now that's a policy that doesn't apply to a particular individual. It applies to a group of individual, all those people under the age of 21, and age is a protected characteristic, and therefore that population would be discriminated against indirectly. So that's the kind of the difference between the two types of discrimination. Harassment is something slightly different, and we'll look at harassment in a short while, but that's about somebody being put into an environment that makes them feel uncomfortable, and a lot of what we'll talk about today kind of fits within that category as well. Now there are standalone claims for discrimination, both direct and indirect, and there are standalone claims for harassment too, but generally speaking they tend to all be with other claims as well. So when I'm in the employment tribunal, rarely is there just one claim. There's more often than not a claim for unfair dismissal or constructive dismissal, and that would be tagged on with a direct or an indirect claim, and perhaps a harassment claim, and maybe a whistleblowing as well, and those sorts of things as well. So it isn't, so whilst there are standalone claims, actually what tends to happen is that those claims are joined together, because as you might imagine, if somebody feels that they've been discriminated against, they may well have resigned, or perhaps they've been dismissed because they have a particular protected characteristic. So not only do they bring the unfair dismissal claim, but they'll also bring the discrimination claim as well. And that's important because on a straightforward, inverted commas straightforward, unfair dismissal claim or constructive dismissal claim, the amount that the tribunal can award is capped. It's either capped at a year's worth of salary that the individual earns, or roughly £80,000–85,000, that sort of region. That's the cap. But in a discrimination claim, that cap is removed. And so therefore discrimination claims, if you've read in the papers or seen on the news the types of claims where people are getting multiples of hundreds of thousands of pounds, those will be discrimination type claims. Those are typically the types of claims. It's also important because if you have a straightforward unfair dismissal claim, the individual employee has to have 2 years service in order to be able to bring that claim, whereas anybody can bring a discrimination claim even if they're not employed. So for example, somebody who is a candidate in a recruitment process, and if they feel that they've been discriminated against as part of that process, they're not an employee, but they can certainly bring a claim against the employer even though they're not an employee, whereas for obvious reasons only employees can bring unfair dismissal type claims. Okay, so that's discrimination. Now, there are, sorry, next slide, please. There are these different types of protected characteristics. So the Equality Act 2010 is the piece of legislation that we're talking about here. And what that does is that sets out the different types of protected characteristics that people get the protection from being discriminated against. So you can see there the different types of protection, and some of them you will obviously be recognise, hopefully, some of the obvious ones, that sex and race and disability, and hopefully that's not new news to anybody that you get protection. But there are some others that you might not necessarily have known that you would get protection from: marriage and civil partnership, gender reassignment, perhaps, as well. So there are some that are perhaps more widely brought claims in the Employment Tribunal, and some less. And I've put there just a few watch outs in terms of the protected characteristics as to what employers often find themselves being tripped up by. So, for example, sex discrimination type claims often includes equal pay legislation. There's a large raft of claims going through the employment tribunals at the moment that relate to equal pay legislation, and effectively what that is, that predominantly men are jobs that are predominantly done by men are compared with jobs that are predominantly done by women, and is there a difference in their pay, and are those jobs sufficiently similar that the same employer should be paying them the same level of pay. So classic examples in local authority are things like the comparison between dinner ladies and refuse collectors, bin men. Could it be said that they are doing work of equal value, and therefore should they be being paid the same amount of money? And because statistically and traditionally more women tend to be dinner ladies or lunchtime assistants, and traditionally, statistically, more men tend to be bin men or refuse collectors, then you can see that that's how you would get that equal pay type claim. Pregnancy, maternity, the protection starts from the moment someone tells you that they're pregnant, so you can't treat somebody less favourably because of the fact that they are pregnant or on maternity leave. That often might sound like it's fairly obvious, but we often get asked questions around, well, if this person's on maternity leave and we want to replace them, can we do that? What should we do? So those sorts of questions often come up. Marriage and civil partnerships. So I said that this is one that's perhaps less common, but it's certainly a protected characteristic. So you can't treat somebody less favourably because the fact that they're married or not married, or in a civil partnership or so on. And so therefore you can see how protection can be gained in that respect. Race, I'd like to think it's fairly obvious that that there's protection from discrimination on the basis of someone's race, but it's a group of people defined by their race, colour, nationality, and it includes citizenship, other national origins, those sorts of things. It's not just the colour of their skin, which perhaps sometimes people may feel that is the more obvious type of claim that employers tend to receive, but it's much wider than that. And nationality is often one. We are in discrimination-based claims. Quite often, you get the sort of banter cases, and you get people with nicknames, and nicknames are very commonly associated with nationality. I'm not going to say them, but you can probably all guess what those are. If you happen to be Scottish, you might have a particular nationality-related nickname. If you happen to be Welsh, like I am, you might have a particular nationality-related nickname, and that's an act of discrimination. Effectively treating somebody less favourably on the basis of their nationality. So, those banter cases are really difficult because an employee may well have gone along with it for a long time, and then actually they might think, you know what, I don't like this anymore, and that's absolutely fine in the employment tribunal's eyes, to say I don't want to be called that anymore. So just be employers need to be very, very careful. Disability, hopefully most people are aware of what was the Disability Discrimination Act, what's now the Equality Act, and the protection that employers have to give to people with disabilities, and in particular there is a positive obligation on employers to make reasonable adjustments. Now, there aren't many cases in law where you have to make a positive discrimination, where you have to act positively for an individual, but this is one of them, where somebody who has a disability, you're under a legal obligation to consider adjustments that you might need to make to assist that individual. And I put there. Sorry, just Brian.
Just on that front, we've got a bit of an interesting one at the moment, in that we've had a machine operator vacancy come about. So this is operating heavy mobile equipment, and we've had a guy apply that has got one arm and has previously driven machines and had no issues reportedly. That does bring up some questions for us in terms of, if he's only got one arm, how does he maintain 3 points of contact getting in and out of the machine? But those are exactly some of the conversations we're having at the moment. And it was a bit of a surprise to me when you said that anybody can bring a discrimination claim, not necessarily an employee. So, obviously, I want to make sure that we do handle it properly. And how would you sort of frame letting somebody down in that aspect without falling foul of the protected characteristic?
Yeah, and it's really difficult, Brian, because what you've got to do is you've got to consider, and unfortunately, or frankly, the larger the business, the more emphasis there is, the more requirement there is on the employer to make these reasonable adjustments. I don't want to say the less reasonable the adjustment needs to become, but for example, I've done cases where a disabled employee has worked in a particular office where the toilets were upstairs, and they were unable to go to the toilet, and so therefore they had to leave their job. And the employment tribunal said in that particular case, it would have been reasonable for the employer to have found a way of either putting a toilet downstairs or finding a way that the employee could have got up the stairs, whether that's with a lift or a chair lift or whatever it might be. So and that was because that employer was quite a big employer. The deeper the pockets, the more likely it is that they have to do that. In your case, strangely enough, I've done a case very similar to that with a gentleman who only had one arm, who was driving a FLT, a forklift truck, and he was dismissed because he'd had 2 accidents. And he said that he was dismissed and he had the accidents as a consequence of his disability. And it was true. He had accidents as a consequence of his disability, because there was a medical report that said that was the case, and in those circumstances we were able to successfully defend the claim for that particular client, because whilst yes, he was treated less favorably, he was dismissed because of his disability. We were able to effectively justify that by saying, well, yeah, but we can't have accidents. You've got to be able. That's why it's a reasonable adjustment. It has to be reasonable in order for the employer to not, I'm not going to say put up with, but to allow the situation to continue. So, that is, it does need to be reasonable, and what's reasonable for one employer isn't necessarily what's reasonable for another employer. And so these are the sorts of conversations that frankly, you need to be having with your HR or legal teams to kind of say, okay, how do we deal with this situation? How do we resolve it? Now, what the law does not do is it doesn't require you to employ somebody where it just wouldn't be right to employ them because of their disability. You can refuse where the disability would make it impossible for them to do their job. I once did a claim with a gentleman who had reduced eyesight, and he'd applied for a HGV role. Now, he had an HGV license, but because of his failing eyesight, our client required all candidates to take the test, and he failed the test, and he then brought a claim. Now, we won that claim. You won't be surprised, and hopefully relieved to hear that we won that claim on the basis that it was not reasonable to have allowed him to continue for obvious reasons. But that bar of what is reasonable is high, and it gets higher. The bigger the business you are, the easier it is to make that adjustment. So don't just assume that, it's going to be difficult to do, and therefore we shouldn't have to do it. There's a lot of things that need to go into that consideration. Okay, so that's disability. Sexual orientation, hopefully that's a fairly obvious one as well. Clearly you can't discriminate, you can't treat somebody less favorably on the basis of their sexual orientation, and as we've put there. Religion and belief is an interesting one, not really because of the religious discrimination, because that should be fairly obvious that you can't treat somebody less favourably on the basis of their religion. But perhaps the fact that this belief is getting wider and wider and wider, because it includes ethical beliefs as well. So things like veganism, psychics, belief in environmentalism, some pagan beliefs are now considered to fall within that category, the religion or belief category. And frankly, that's getting wider and wider and wider. And so therefore, if somebody says that they have a particular belief system and they live their life to that, then they're likely to get some protection. I put there environmentalism. A claim that we did a few years ago was a gentleman who'd been selected for redundancy as a consequence of his poor attendance record. He was often late for work, and he was the person who was selected for redundancy. Now, he was often late for work because he was a staunch environmentalist. He didn't believe in public transport. He didn't believe in any internal combustion, and he only cycled. Everywhere he went, he cycled everywhere. And he said that he was late because he was cycling in, and therefore he should be protected. And the tribunal agreed that he should be protected because of his environmentalism. He could demonstrate that it was his ethical belief. He genuinely lived his life by that, and he could get that protection. Now, he didn't win his claim because he was still able to be successfully made redundant because of his poor attendance, because just because you ride a bike doesn't mean that you should be late for work, right? So that was the point. And so therefore our client was able to successfully defend the claim to say, yeah, but he still, we don't really care how he gets to work. It's because he's late that he's low down on the scoring mechanism for the redundancy. But it's just interesting that the tribunal were quite prepared to say, his environmentalism gives him that protection. So interesting there. Age discrimination, so you can't be discriminated against, you can't be treated less favorably on age, and also the perception of age as well. So I spoke about the insurer, the indirect discrimination claim, where a business doesn't employ people below the age of 21 because for them the insurance would be too much for their fleet. Now that's an act of indirect discrimination, but you can objectively justify those types of things. And in that particular case, the employer was able to objectively justify it because actually, if they have had to employ people under the age of 21 to do that driving role, it wouldn't have made what they were wanting to do viable. And therefore, they were able to objectively justify that. Now, that was a few years ago. Whether or not that would still be the case now, I don't know. But it's about perception of age as well. So again, banter, nicknames, those sorts of things. Somebody who might look young for their age, young so-and-so, someone who might look old for their age, old so-and-so, whatever it might be, those attract protection. So it's not necessarily how old they are, it can be about the perception of their age as well. And then the final one, gender reassignment, and hopefully that's fairly obvious in terms of the protection that somebody would get. And that happens from the point that someone tells you that they're considering gender reassignment. Next slide, please. So that's discrimination, and we've done bullying. So I just wanted to talk just quickly about what sexual harassment is, because this is a slightly different area. So it's linked in many ways to discrimination, but I thought it was useful just to have a conversation about what sexual harassment is, because increasingly within the workplace, we are seeing claims for sexual harassment. Now, whether that's because people are more aware of it, whether that's because people are more aware of their rights to do so, I don't personally think it's because it's happening more. I think it's just that people are aware that it's unacceptable, and perhaps what somebody might have put up with 5 years ago, they won't put up with now, quite rightly, frankly. And so therefore, what we're tending to see is an increase in these sorts of claims. And what it is as we've put there, so the strict legal definition is that it's unwanted conduct of a sexual nature that has the purpose or effect of violating a person's dignity or creating an offensive, intimidating, or hostile environment for them. Now, that's quite legally. If we break it down, it's actually relatively straightforward to understand. So the first point is that it's unwanted conduct. So that hopefully is fairly straightforward. Now, the difficulty with what is and isn't unwanted conduct is that what somebody who gives the conduct perceives to be wanted or unwanted can be very different from the person who receives that conduct. And the test in the employment tribunal is that it's the way in which the person receives that conduct. So it's how I feel about it. And if I say that it's unwanted, then generally speaking, it will be unwanted. And that can create difficulty. Christmas parties, the advances of one colleague towards another colleague, is that unwanted, is that wanted, and so on. It creates a bit of a minefield in that respect as well. So bear in mind, and particularly with sexual harassment, that it's about the way in which I perceive it, the way in which it's received by me. That's the important point here. So that's the unwanted conduct that has the purpose or effect. And this is where the victim reasonably feels that they've been harassed. So the person who's receiving it has to reasonably feel that they're the one who's been harassed. Now, the word there is reasonable, and employment lawyers love the word reasonable because it doesn't have a stop point. There's a sort of a startish point over here, and there's a stoppish point over there. But the reality is of what is reasonable is often within what we call about a band of reasonable responses. And so the purpose or effect, it has to have had either deliberately been done or had that effect on that individual. So that unwanted, it needs to be the unwanted conduct, and the victim reasonably needs to feel that they've been harassed. So the reasonableness test is the test that the tribunal will look at. So the more serious, the more severe the issue, the conduct, or whatever it might be, the more likely it is that that's going to be an act of harassment. Now, then it needs to have created an offensive, intimidating, or hostile work environment. And it doesn't take a huge amount to create such an environment. It doesn't take a lot to convince an employment tribunal that this environment has been created. I can think back to work environments that I've worked in before I was a lawyer, working in retail, working in pubs, working in all sorts of different places, and thinking about those environments, and they would definitely be offensive, intimidating, and hostile. It doesn't take a lot. It's a poster on the wall. It's the type of language that's used. It's the intimidating nature of the environment that is quite easily created. And remember that it's how I feel. It's how I perceive it to be. It's not how the people intended it to be. Very, very common defense from somebody in a disciplinary scenario, for example, is I never intended that person to feel the way that they felt. And the tribunal will go, we don't really care how you intended the person to feel. What we really care about is the way in which the person felt. And that's the important point here. So that is harassment. And then for sexual harassment, it has to be of a sexual nature. If it isn't, it can still be discriminatory harassment, and it can still constitute bullying. But in order for sexual harassment, it has to be of a sexual nature. And we're going to look at some examples shortly as to kind of what that might include. But it ranges from the really serious things that you would expect to obviously be an act of sexual harassment to some that you might be slightly surprised about. And so that's probably a good point to go on to the next slide, Louise, if that's okay. So let's have a look at some of these. So examples of sexual harassment, and these are all cases that I've done over the years of the types of things where the tribunal have gone, yes, that is an act. So deliberate physical conduct, touching, pinching, pushing, grabbing, brushing past. So I've done cases on all of these things. So the fairly obvious ones of kind of pinching and touching inappropriately, they will clearly obviously be. The brushing past one, done quite a few of those sorts of cases, and the individual will say, well, I was just squeezing past them, but it's the way in which remember the way in which the individual feels, the way in which they received that conduct, which amounts to the act of sexual harassment. It should be fairly obvious that the sending or displaying of pornographic images is going to be an act of sexual harassment. Likewise, sexist jokes, sexual assault and rape obviously is going to be. But some of the more nuanced stuff, these things about asking questions about someone's sex life, being open about your own sex life, it can be an act of sexual harassment. So did a case where an individual was very open about her sex life, and was always talking about it in the office, and somebody else made a complaint about it, and the person who was talking about their sex life was saying, well, I'm not talking about their sex life, I'm talking about my sex life. Surely I can talk about what I want. But that isn't the case. It's creating that hostile, that intimidating environment. It's of a sexual nature, and therefore that can be an act of harassment. And so it doesn't necessarily need to be about that individual. It could be about somebody else. Sending sexually explicit text messages, sexual gestures, threats for rejecting sexual advances, offering rewards, that sort of stuff, can often amount to acts of sexual harassment. So, it is a much wider area for people to be able to say that they've been discriminated against. And I know I keep coming back to this, but remember that it's about the way in which I feel, the way in which it lands with me. It isn't about the way in which it is intended to be done. So I talked about a hostile environment. So I did a case just last year where a group of men had on the wall a poster, a calendar that had some topless women on, and another male member of staff had complained about that, saying that that was pornographic, felt uncomfortable. They refused to take it down, and they were disciplined when they didn't take it down, and brought claims saying, well, what's wrong with that? And also the individual who made the complaint brought a claim, sexual harassment as well. And bear in mind that that was a heterosexual man bringing that claim, but he was still able to demonstrate that it had created that intimidating, hostile environment. It was of a sexual nature, and therefore it had the purpose of effect, and it was unwanted. And so therefore he was able to demonstrate that it was harassment, and so therefore he was successful in his claim. So even in that sort of environment, you can see how that is unacceptable, and hopefully the world has moved on a little bit from the sort of 70s and the 80s, but we still see it. So even last year I had a case on that. Okay, next slide, please. So just a few points to remember on sexual harassment. So it doesn't matter whether there's that intention to sexually harass somebody or not. Remember, I know I keep going on about it, but it's the way in which the recipient feels. That's the focus. Unwanted conduct doesn't have to be specifically directed to a particular individual. So the case with the topless calendar, it wasn't directed at the complainant. He just happened to be in the same work environment, but he felt uncomfortable about it, and therefore he was able to successfully bring that claim. And it can be witnessed or overheard. So I won't give too much away, but we've got a worked example in a moment about somebody that overhears or who oversees something. A one-off incident can constitute harassment, as well as ongoing incidents. Now, so it can be a one-off incident, as you would hope it would be. What I would say is, if it was less serious, then the chances are the one-off might not be an act of harassment. So let me give you an example. I'm doing a case at the moment for a client where a male member of staff has given to a female member of staff a bottle of perfume. Okay, so on the face of it, it's a gift. Is it that big a deal, etc.? But the female member of staff feels uncomfortable with this and has asked the male member of staff not to do that again, not to give her any gifts at all. So on the face of it, that one-off incident, I think they'll maybe struggle to argue that that's an act of sexual harassment. It's not the most blatant act, is it? However, if that, and this hasn't happened by the way, but if that male employee then gives, having been told not to do that again, gives another bottle of perfume or another gift or something like that, you can see there that this is an ongoing incident and therefore could quite easily then become an act of harassment. And so that's the difference between the kind of the single not so serious event, which could be innocent, versus the kind of the more blatant repeated issue. Employee may still be liable for sexual harassment even if they're not aware of their own behavior. So sometimes people will say, well, I didn't know that it was going to have that impact on that individual. But if it's bad enough that actually it's reasonable for somebody to have felt that they could have had that impact, then that's not a defence. It's no defence to say, well, I didn't realise it was going to have that impact on them. That's not a defence. You should have known. So, it's lawyers like to say you knew or ought to have known that it would have had this impact or could have had this impact on this individual. Definition of employee in the Equality Act is wide, so it covers workers, covers some self-employed people as well, when they're providing their services personally. And sexual harassment can happen to men as equally as it can to women. Employees can be sexually harassed by people of the same sex or the opposite sex as well. And as we saw in my calendar on the wall example, that was an all-male environment. Okay, next slide, please. So obligations of the employer, avoiding some of these issues. So under the Equality Act, the employer is vicariously liable. And what that means is that they stand in the shoes of the employees carrying out these acts of harassment. So the employer will be responsible and can be responsible for the acts of their employees carrying out these acts. And so therefore, things to do to minimize as an employer your exposure: implementing equality policies, providing training, dealing effectively with complaints. Sometimes people will have a dedicated confidential helpline, training managers, reviewing policies, and ensuring that policies are employers and workers are aware of what those policies say. I can't really stress enough how important it is if you are an employer looking to try to defend a claim of harassment, to be able to say, well, we did as much as we possibly could. We trained everybody. We told them that it was unacceptable. We made it very clear that this behavior was unacceptable. And therefore, this is just their individual on their own who's acting in this way. If you haven't done that training, then it makes it very, very difficult to run that defense. Next slide, please. I put a few cases here about what in the course of employment means, and I'm not going to go through them all, but ultimately what these cases demonstrate is that what can be work is getting wider and wider and wider. So things like colleagues in work time but not performing their duties, that can absolutely be work. In a work organised social function down the pub, that can absolutely be work. And in actual fact, it's getting wider and wider and wider. There doesn't need to be much of a connection between the work environment and where the incident took place for the employer, for it to be brought in and the employer to be responsible for it. Christmas parties are a classic example of these sorts of things. We've organised a Christmas party, everybody's got really, really drunk, and then they've gone to the pub afterwards or whatever, and then the act has happened, the harassment has happened in the pub afterwards. But the trouble is, it's so closely linked to the Christmas party that was going on before, and we provided the alcohol and so on, that more often than not, that will be caught. Now, I'm not the fun police. I'm not here to sort of say, don't do this, don't do that, you shouldn't do this, you shouldn't do that. But employers need to be aware that their responsibility is much wider than they often initially think. Next slide, please. And so what are some of the potential legal liabilities? So an employer can be responsible for an act of harassment under the Equality Act, as can the individual themselves. There is potentially the breach of a statutory duty to provide a safe working environment, and we're increasingly seeing that. Now, I know, given the industry that we're in here, that health and safety is a significant part, and increasingly what we're seeing is health and safety forming part of this. A safe working environment is not just about making sure that you've got PPE and the things in the right place. This is also about providing a safe environment that people can work in from a mental health perspective, from a harassment perspective, from a discrimination perspective as well. And it's a real growth area. And people are often surprised by that, but we're increasingly seeing that as something that the breach of that statutory duty to provide that safe working environment. Negligence claims are quite common. particularly in harassment, discrimination cases. It's very common for employees then to have significant mental health problems as a consequence of bullying and harassment or discrimination, and that limits their ability to work going forwards. And that's when you can get those really big numbers in the employment tribunals, because somebody who might have been earning X amount of money now can only earn Y amount of money. And if they can link that directly to the behaviors of the employees, and you've not properly trained them, and you could be standing in their shoes, that's that vicarious liability, then ultimately an employer might be responsible for that as well. Constructive dismissal, we spoke a little bit about at the start, where an employee resigns because they say that there's been a breach of that trust and confidence that exists between an employer. And then there's also personal liability for the harasser. So in the employment tribunal, an employee who brings a claim can not only bring a claim against the employer, which they would always usually do because the employer's got deeper pockets, but they could also bring the claim against the individual harasser as well. And that can be quite a difficult situation for somebody who, particularly in those cases where someone might not have intended for an act of harassment to have taken place. I didn't mean to do that. I didn't mean to speak in that way. I didn't mean to touch in that particular way, or whatever it might be. And the employment tribunal will and can make awards, damages awards against individuals. So again, training is a really important part of this, about people being aware of their responsibility, about being aware of not just about scaring people to say you could be liable, you could be responsible for this. This is about people knowing that actually you've got to be responsible for your own actions, for your own deeds and your own words as well. So you'll be pleased to know that that's kind of the law. And just to finish off with, I've got a few case studies that I thought I might just run through with you to see what you might think. So next slide, please. So, and these are all real cases, these are. So a female worker works at a car dealership, and there's a culture of sexual banter, sexual behavior in which she and her manager actively engage in it. So this is banter two ways. Manager makes speculative comments about the female employee's sex life, relationship with her boyfriend, and also other people who've worked at the dealership. The manager also attempts to kiss her. Is this sexual harassment? What do people think?
I'll go first.
Yeah.
I would say definitely yes.
Yeah, you're right. You're absolutely right. So if you go on to the next slide, please. So yeah, this is a case called Smith and Renrod. And even though Miss Smith had participated in, and in some cases she'd initiated this sexual banter with the manager, it went beyond what was acceptable for her. Tribunal considered that female employee might be compelled to join in if there's a culture in that environment. So quite often it is not unreasonable for an employee to say, I had no choice. I wanted to feel like I was part of the team, part of the group, and therefore I felt like I had to engage in all of this, even though I didn't necessarily agree with it. And the tribunal wasn't swayed by the fact that Renrod, the respondent here, had sent the manager on some discrimination training. And what they should have done is they should have taken steps to prevent that sexual banter taking place in the workplace. What they were saying is that the employer, Renrod, had provided the environment for this act of sexual harassment to take place, and that was what got them into trouble. They'd allowed this environment to happen. So even though Miss Smith in that particular case had participated in it, and then on some occasions had started that kind of banter, that conversation, it had gone beyond what she felt was acceptable. And this is where these cases are really, really difficult, because very regularly people will say, oh, I didn't mean, we were having a joke and a laugh, and I didn't really mean for it to be taken in that particular way. And the employee can say, well, that was all right 6 weeks ago, but today that's not all right. And the employee has the right to say that. So very, very difficult in those scenarios. And the lesson really is, we shouldn't be having an environment where this is acceptable, which has to be right. And again, I'm not the fun police, but there has to be a level of responsibility, particularly at management level, where people are going, no, we shouldn't be talking like this. We shouldn't be having these sorts of jokes, these sorts of conversations, because they absolutely do come back to bite you. They really, really do. Okay, next slide, please. So female employee aware of 3 occasions when male employees downloaded pornographic images onto their computer screens. She wasn't shown the images and didn't make any complaints at the time. Do we think that? So do you remember I said before that the individual doesn't necessarily have to see the acts? What do you think? I've kind of given you a clue.
Yeah, I guess if she felt uncomfortable by it, then you would say yes.
That's right. Yep. Next slide, please. Yeah. Interestingly, the tribunal initially found that there was no discrimination, and they found that because she hadn't seen it and she wasn't aware of it, and she waited some time to complain. But then it went to the Employment Appeals Tribunal, the EAT, and they did find that it was discrimination. And they said that it obviously would undermine the female employee's dignity. And again, it's that thing about, you know, there's an environment that's been created here which is wholly wrong, which accepts and allows that. And therefore that clearly was an act. Okay, next slide, please. Female employees subject to unwanted sexual behaviour from a manager. Although the incidents were fairly minor, they had a cumulative effect. So joked about looking up her skirt, showed a newspaper cartoon, told some dirty presents, some dirty jokes in her presence, and then said about screaming and taking her clothes off and so on. What do we think?
Sounds likely, I would say.
Yeah, absolutely. Next slide, please. As we know, sexual harassment can be an accumulation of minor incidents. So it doesn't have to be something really, really big. It can be that accumulation. And sexual harassment can also be one incident, as we know. But I think in this case, it was an accumulation of the smaller one. Next example, please. Female manager. So this is a female manager massaging the shoulders of a male employee whilst he was sitting at his desk. Manager claims that she only tapped his shoulders on one occasion, and the claimant had encouraged her in that. Was it sexual harassment and discrimination? All right, I'll put you out of your misery. Next slide, please. Now, interestingly, very interestingly, the answer is no on this case. So, tribunal rejected manager's account and said that actually they found that she had massaged the claimant on a number of occasions, and that she'd done so for encouragement. Tribunal found that the employee had suffered unwanted conduct which had the effect of creating an intimidating environment. However, dismissed the claim on the basis that the conduct wasn't related to his gender or that it was sexual in nature. Now, I have a bit of a problem. This wasn't one of my cases. I have a bit of a problem with this case because I think classically this is only because it was a female manager rubbing the shoulders of a more junior male employee. I think if it was the other way around, it absolutely would have been an act. Absolutely would have been an act, and therefore I actually think this is badly decided. You know, sometimes you don't agree with judgments that are made in the employment tribunal, and for me, this is one of them. Okay, just a couple left. So next slide, please. Sinead's 19, junior member of staff. She doesn't have a good attitude at work. Not happy when a manager takes her to task for her attitude and poor performance. He calls her a stroppy little teenager. So, what do we think? Is that bullying, harassment, discrimination?
Potentially discrimination because of her age, is it?
Yeah, age discrimination.
Yep. Next slide, please. So the definition of her as a teenager was an accurate description, and that's what the employer was saying was, well, she is a teenager. But the way in which it was said, the kind of the derogatory, stereotypical way, that's the act, the Discrimination Act, the Age Discrimination Act, and she was injured £2,000 for injury to her feelings. Interestingly, and then the final example is this one. Employee is heterosexual, subject to sexual innuendo at work, suggesting that he was home. Colleagues make joke about the fact that he'd been to boarding school and wasn't gay, but they still made jokes and made jokes about him being gay. What do we think? Discrimination, harassment?
Some sort of harassment, maybe.
Yeah. Next slide, please. So, doesn't matter that he isn't gay and that they know that he's not gay. It's this incessant mocking, creates this hostile working environment. It was on the grounds of sexual orientation, regardless of the sexual orientation of the person who receives it. Remember that it's about the person who receives it, and therefore it's an act of discrimination and an act of harassment as well. Good. So we just got 5 minutes. So thank you for that. Questions?
Is there anything of interest that's come out of the recent sort of pretty high profile case with John Burko at all? That was quite a sort of a high profile bullying sort of.
Yeah, absolutely. And what's interesting about that is that it's a classic example of people not really saying it, because what I found interesting about that case was at the time, no one was really complaining about it. From the outside, I've not been involved in it, so I don't know, but from the outside looking in, it doesn't look like people were complaining about it. And then these things tend to have a snowball effect. One person complains, another person complains, and then a number of people complain. And actually, I have read some of the report, and it's pretty damning in terms of his behavior and some of the things that he was saying. But some of this stuff dates back 10, 15 years, the people who used to work for him. I think there is around Parliament, there is almost a feeling of this place is different. It's a different work environment, but of course it's not. It's a work environment. And so therefore the same level of respect, the same levels of obligations on employers apply in that work environment as they do in your work environments. And so therefore I don't think much will change, because hopefully it has changed significantly since he's not been speaker anymore. But it's one of those situations where I absolutely can see it, and it's very, very common with sort of senior people who behave in that particular way and have been allowed to behave in that particular way, and only when it gets called out by a number of people do people go, yeah, that was really bad, wasn't it? That was really bad.
Okay.
Any other questions?
I only had one more, just out of interest. You sort of talk a lot about maybe sort of cases where it's employee bullying another employee, or perhaps the employer bullying the employee. Are there many cases where it's the other way around and it's sort of more upwards rather than downwards?
And you know what's interesting is that we're increasingly seeing that as well. So there is absolutely a concept of reverse bullying, because there's no legal definition. No one really knows quite what to call it. But I'm doing a case at the moment for a client where a more junior employee has hugely undermined their manager over a long period of time, and effectively that is bullying. And there's probably harassment in there as well. They've probably created that environment, and that's quite difficult, I think, for the manager, because traditionally the manager should be seen to be able to manage that situation. But what we know about bullies is that they don't conform to the normal stereotypes of what they're supposed to behave like, and so therefore that it's a very difficult. So yeah, I mean, it's a really good point, Brian, because we definitely are seeing more and more of that, and managers are aware that they don't have to and shouldn't have to put up with that sort of behavior as well, which is absolutely right. So it does cut both ways. It by no means is it common, and it's very much the other way around normally. But like I say, I'm advising one client at the moment on it, and it's not the first time. I've definitely seen it in an increasing amount. And it's about, for me, creating an environment that's respectful to work in. So it doesn't and shouldn't matter what the level of seniority is and the power dynamic between the two or three or more individuals. It should be about people being allowed to work in an environment that is respectful to all, irrespective of whether they have a protected characteristic or not, frankly. That's what it should be. And like I said before, I definitely think and subscribe to, if you can create that environment and make a real virtue out of that environment where it is a great place to be and a great place to work, you can use that to your advantage, particularly when you're in industries where it can be difficult to attract talent, where you're missing out on a really big talent pool. And I definitely think that's something that more and more industries that are missing out on that talent pool should be looking at and saying, come work for us, because we're a great progressive place to work. It's really great. You'll be welcome here, you know, and to use that to your advantage. And I really subscribe to that.
Okay, good. Thank you very much.
Good.
Bryn, I've got a question. When pay scales are kept discreet, we'll say, rather than secret, how can you justify people's salaries and people asking on individual contracts for a pay rise when they don't know what their equivalents in the company are earning?
Yeah, and the answer is that you don't have to justify. You can pay people whatever you want to pay them, provided you're not doing so in a way that is treating them less favourably on account of a particular characteristic, or whether they're full-time, part-time, whatever it might be. So there's no legal obligation on you to pay the same amount of money to people if it's not discriminatory, if you see what I mean. So and market forces dictate levels of pay. Location sometimes dictates level of pay, that sorts of stuff. And so if someone says, well, I don't know how much he or she is getting paid, how do I know what should be right? I guess what you have to say to them is, well, we've carried out our own analysis. The person who makes the decision as to what people get paid, we've carried out our own analysis, and we're satisfied that the amount of pay that you're getting is correct for your job role and your level of experience and your qualifications, and you know the things that you are allowed to judge people on how much they get paid by. But I appreciate it can be difficult. You know, it's funny that particularly in law firms, quite often law firms will publish, you know, what the rates of pay are. You know, and interestingly, increasingly, I'm working with clients where they are really transparent of what rates of pay are. You know, if you look at the NHS, for example, everyone has a rate, you know, a scale, whatever you are, and so therefore people can usually work out roughly what people are on. More traditional industries are less so, which I absolutely get. And there are, I'm not saying that that's right or wrong, but you know, you can definitely see that I think there is a move towards some transparency. Good. Well, we're 3 minutes over, so hopefully that was helpful. Thanks ever so much for having me. It's been great to talk. So thank you, everybody. Obviously, if I can ever help with anything, then look me up. I'll be more than happy to help. And thanks ever so much. I appreciate the opportunity.
Thank you very much, Bryn. Thanks
Good.
on behalf of the Institute. Thank you very much. And yeah, hopefully people won't have to contact you.
Yes, yeah, exactly. Yeah. I don't take it exactly. I don't take it personally when people say, I hope I never have to see you or speak to you again. I don't take it personally, so don't worry. But if you do, then I'll be more than happy to help.
I do. Thank you very much.
Great. Thank you, everybody. Thanks. Bye-bye.
Bye-bye.